Intestate succession under the Indian Succession Act of 1925. First, I'll tell you about the topic in general. The Indian Succession Act of 1925 primarily governs the intestate succession, distribution of property when a person dies without a will. Intestate means without a will. Testamentary succession is when a person dies with a valid will. For who? For the Christians and the Jews, and some other communities that are not covered in the Hindu, Muslim, or Parsi personal law. It also applies to the Parsis, but with special rules, different chapters. The Hindus, the Sikhs, the Buddhists, and the Jains follow the Hindu Succession Act of 1956 for the interstate succession. So, Part 5, Chapter 2, that is Section 31 to 49, these are the rules for interstate succession applicable to Christians and Jews or similar groups which are non-Parsis. And Part 5, Chapter 3, Section 50 to 56 is the special rules for Parsi intestates. The Act does not apply to the Hindus or the Muslims for interstate matters except in limited cases. For example, during Special Marriage Act, a person who is Hindu or Muslim marries a person who is Christian or Jewish. That's when this would apply to them as well in interstate succession. A person is deemed to die intestate in respect of property for which no valid testamentary disposition or will is capable of taking effect. There are recent amendments like the Repealing and Amendment Act of 2025 which have removed certain probate requirements under Section 213 for uniformity. But the core interstate rules remain largely unchanged. Always check for latest consolidated versions. This is just AI nonsense. The key definitions. Widow, widower. A man dies, the widow is left behind. The woman dies, the widower is left behind. Man and woman is the husband and wife. Surviving spouse. The lineal descendant, that is the children and the grandchildren and the great-grandchildren, etc. Direct bloodline descendants. Kindred, these are relatives like parents, siblings and their descendants. Broader blood relative, excluding the lineal descendants in some context. So siblings or their children. Next, property devolves according to the rules prioritizing spouse and lineal descendants. Who is kept as first priority is the spouse and the lineal descendants, the children and grandchildren. The interstate succession rules for Christians and Jews, Section 32 to 49. Section 32 provides for the general framework. Property devolves upon the widow or widower or the kindred in the specified order and manner. Number 1, if the intestate leaves the widow with lineal descendant, that is there are children or grandchildren, the widow gets 1/3 of the property and remaining 2/3 go to the other lineal descendants per stripes. That is, if a child predeceases, their share goes to the children, 1/3 and 2/3. If there is only one child, it will go entirely 2/3 will go to them. If there are more children than one, then this is divided fractionally amongst how many ever children are there. Without lineal descendants, but with kindred, example parents or siblings, that is there are no children or grandchildren, but there is a widow. Then the widow gets half of the property and the remaining half goes to the kindred in the order prescribed, that is father first. If the father is not present, then the mother and the siblings. The widow alone, no lineal descendants or kindred, then the widow will take the entire property. If there is no widow, but lineal descendants do exist, the property goes entirely to the lineal descendants equally. The sons and the daughters have equal shares. The distribution per stripes for the deceased descendants. If no widow or no lineal descendant, that is widow is not there, lineal descendant is not there, property goes to the kindred, the relatives in the following order. Father, if alive. If not, then the mother, brothers and sisters. And their children, if predeceased, the brother and sisters. Not the mother's children. Mother's children are your brothers and sisters. More distant kindred if closer ones are absent. Uncles, aunts, stuff like that. If there are no kindred people at all, then the property escheats to the government as a bona vacantia. That means nobody is there to claim the property. Additional rules, the distribution amongst the lineal descendants. There are equal shares. The children of a predeceased child take the parent's share. For example, here if there is a brother and sister, there are 2 brothers, 1 sister, and 2 brothers are alive but the sister dies. Whatever share the sister would have gotten after giving the share to the mother, that share is given to the children of the sister if she is predeceased. So child takes their parent's share. No distinction between movable and immovable property in the distribution rules, though domicile rules may affect, which applies to the movable property. Illegitimate children. limited rights in some interpretation under this act, unlike the modern Hindu law reforms, where illegitimate child is also considered to basically be a legitimate child only for succession. Succession is based on proximity of relationship. There is no fixed class 1, class 2 hierarchy like in the Hindu law, but a clear order favoring the spouse, lineal descendants, and finally the kindred. When we talk about the special rules for the parsis, section 50 to 56, parsis have a distinct scheme. The property is divided among spouse, children, and sometimes the parents or the siblings with specific shares, generally more equitable among the immediate family, with rules for representation per stripes. For example, the widow and the children share, with the children getting equal portions, special provisions if there are no children. The Parsi rule emphasizes class 1 heirs, the spouse and the children first, then the class 2 heirs, that is the parents or the siblings. Some more important points before we reach the subtopic 1. The domicile and the property type. Succession to immovable property is governed by the law of the place where it is situated. Movable property follows the law of the deceased domicile at death. Domicile is the place where they lived. No will, that is intestate. Even partial will means the undisposed property follows intestate rules. That means if in the will you've mentioned 4 properties, but the person had 8 properties, so the 4 properties that he has not mentioned in the will be dealt with these rules of intestate succession. The equal rights for sons and daughters, they are considered as one and the same under the Indian Succession Act. For the covered communities, the sons and daughters generally share equally among the lineal descendants. The widower's right. A surviving husband has similar rights to a widow in the estate of his deceased wife as the wife would have had in the husband's estate. The difference from Hindu Succession Act, as I told you, under Hindu Succession Act, there are more equal shares among the class 1 heirs. The widow, the mother, the children all get an equal share. These are detailed in class 1, class 2 list and the co-parsonary and the karta list and all of that concept for the joint family property. Under the Indian Succession Act, where it goes, the widow gets 1/3 with the children or half without. The mother is often excluded if the kindred are present. Now, out of the 3 topics, we'll go to subtopic number 1, the rules in the cases of intestate other than parsis. Here, there is a clear and detailed explanation of the rules for intestate succession when a person dies without a valid will under the Indian Succession Act of 1925. Specifically for cases other than parsi, because that's our first topic. So here we'll talk about chapter 2, part 5, section 31 to 49. These rules primarily apply to Christians and Jews and other persons that are not governed by who? The Hindu or the Muslim or Parsi personal laws. Section 30, intestate. A person dies intestate in respect of property for which no valid will exists. The heirs are recognized. Widow, widower, that is a surviving spouse. The lineal descendants, the children, the grandchildren, the great-grandchildren, etc. born out of a lawful marriage. The illegitimate children are generally excluded under this act. The kindred, the blood relatives other than the lineal descendants, such as parents, brothers, sisters, and their descendants. The collaterals and ascendants. Who are ascendants? Ascendants are your grandparents. Section 32. The property devolves upon the widow. Ascendants are also your parents, by the way. Section 32. The property devolves upon the widow or the widower or the kindred in the order and manner laid down in the subsequent sections. Widower's rights, section 35. A surviving husband has the same rights in his deceased wife's property as a widow has in her husband's property. So, widower's right, a surviving husband has same rights as I told you earlier. There is no distinction between movable and immovable property in the distribution rules, but they are subject to domicile rules for the movable property. Now we'll talk about the widow's share in section 33, where the intestate has left a widow. Situation number 1, widow plus lineal descendant, 1/3 to widow, rest 2/3 to be divided amongst the lineal descendants. Situation 2, widow with no lineal descendant but the kindred exists, half share to the widow and remaining half will be to the kindred in the prescribed order. And widow plus no kindred, entire property goes to the widow. Note on section 33A, the special provisions for the small estates. If there is a widow but no lineal descendants and the net value of the property does not exceed 5,000, which I don't think there can be any property that does not exceed 5,000 in India today, the entire property goes to the widow. This does not apply to the Indian Christians or certain other categories. No widow, section 34. The property goes first to the lineal descendant. If no descendant, then the kindred in the order. But if no kindred at all, the property escheats to the government as a bona vacantia. That means there is nobody to claim the property. Finally, it will go to the government. The distribution amongst the lineal descendants, section 36 to 40, the equal shares among children. Sons and daughters get equal portions. Per stripes rule, that is, if a child has predeceased the intestate, that child's share will go to his children. That if he is a predeceased child, it will go to his or her children or grandchildren of the intestate. The person who died, his children are dead, his children's children will get the share equally. 3 people, 1, 2, 3. The divided share, if wife is present, 1/3 will go to her, 2/3 will go to them. The 2/3 will be divided among son 1, son 2 and daughter. Then son 1 has 2 children, they will get half of the share. The son 2 has 1 child, they will get the entire share of the father. And daughter has 1 daughter, for example, let's assume. So she will get the entire share of the mother, that is the child of the intestate. The specific rules. Only the children surviving divided equally. If there are children and grandchildren, where some children predeceased, that is the grandchildren take the share of the parent would have received, as I told you earlier. Children and grandchildren. So children, this grandchild's father, that is the deceased person's son or daughter, is dead. So that share will go to the grandchild. Some more remote descendants follow the same principle of representation. The distinction among the kindred when no lineal descendants, section 41 to 48. The property or the remaining share is distributed to the kindred in this strict order of preference. Father, if he is alive, takes the entire share. If the father is dead, the mother, the brother, the sister, and the children of any predeceased brother and sister share it equally. This is section 43. If none of the above, then more distant kindred according to the proximity of relationship. Section 44 to 48 deal with them. Following rules of representation were applicable. So again, as I told you, there is no fixed class 1, class 2 list like the Hindu law. The priority is based on the closest degree of relationship, with parents and siblings taking precedence over the uncles or the aunties. The other important points, equal rights for sons and daughters, as I told you, among the lineal descendants. There is no gender discrimination like there used to be in the Hindu law before 2005 Amendment Act. The illegitimate children generally not treated as children or lineal descendants, unlike the Hindus. The adopted children, adoption is not recognized in the same way under the Hindu law for the Christians and the Jews. Domicile, succession to the immovable property is governed by the law of the place where the property is situated. Movable property follows the law of the deceased domicile at the time of death. Partial intestate. If a will disposes of only a part of the property, the undisposed portion is followed by the intestate rules. There is no major change. The core distribution rules, section 3249 as of 2026, through probate related provisions, example 213, has seen amendment for uniformity. Quick example, Christian man dies, leaving widow, 2 sons and 1 daughter. Widow gets 1/3. Children divide the 2/3 among themselves. So 2/3 into 3 parts, that is 2/9 for all of them. Number 2, there is a widow, no children, but the parents and siblings are alive. So widow will get half, the other people are the kindred. The remaining half goes to the kindred, father first, or mother and siblings if the father is dead. Number 3, there is no widow, but there are 3 children. The property will be divided 1/3, 1/3 and 1/3. Number 4, there are no widows, no children, only mother and brother. So mother and brother share the property along with any children of any predeceased sibling. If there is no predeceased other sibling, mother brother ke saath there was no brother or another sister, then they get half. Otherwise, this will be shared differently. These rules ensure a priority based and proportionate distribution, favoring the surviving spouse and the direct descendants first. A disclaimer, this is just AI jargon. Subtopic number 2. We have only 2 subtopics to go. The special rules for who? For the parsi intestate people. Here, there is a clear explanation. AI jargon again. Section 50 sets out the general principles that govern the intestate succession among the parsis. A posthumous child, that is a child who was conceived at the time of the intestate's death, but was born alive afterwards, is treated on the same footing as a child who was actually born during the intestate person's lifetime. That means, if the wife of the man who has died conceived the child with the man before the death of the man, and the child is born after the death of the man, he will be on equal footing as a child who is born, who was alive at the time that the intestate person was alive as well. A lineal descendant of the intestate who died during the intestate's lifetime without leaving a widow or widower or any lineal descendant, that is children, or a widower of any such lineal descendant is completely ignored. There are two brothers, the father dies, but before the father dies, one of the brothers dies. So when the property is being divided amongst the widow and the brother, that is the mother and the brother, the other brother, if he does not have a wife who's still alive, or if he does not have any children who has a wife who is alive, then he will be completely ignored when determining how the property is to be divided. Additionally, if the widow or the widower of any relative of the intestate remarries during the lifetime of the intestate, that widow or widower is deemed to not exist. If the other brother who died had a wife, but she did not remarry, then she gets property. If she did remarry, then she does not get any property. She is deemed to not exist at the time. Additionally, if the widow or widower of any relative or intestate remarries during the lifetime of the intestate before he dies, that widow or widower is deemed to not exist at the time of the intestate's death and receives no share in the property. Section 51 provides the primary rule for division of the property when the parsi intestate leaves a widow or widower and or children. Subject to the limited provisions for parents, the property is divided as follows. Where the intestate dies leaving a widow or widower and children, the widow or widower and each child receive equal shares. If there is widow or widower and children, they receive equal shares. Where the intestate dies leaving children but no widow or widower, the property is divided equally amongst the children. Where the intestate also leaves one or both parents in addition to a widow or widower and children, all three are there, the widow or widower and each child first receive equal shares, then each surviving parent receives half of the share of what the children got. If they got half, they will receive 1/4 and 1/4. I know it doesn't come up to 1 if you think of the numbers I just told you, but please try to understand what I'm saying. If they receive 2000 square meters, 2000 square meters, 2000 square meters, 2000 square meters, that is 3 children and the wife, then the parents would only get 1000 square meters and 1000 square meters. They receive half of the share of each child. Each surviving parent, so 1000 and 1000. Section 52, which were earlier contained the separate rules distinguishing between the male and the female intestate, has been repealed. The distribution under Section 51 now applies uniformly. So there is no distinction between a male and female intestate. Section 53 deals with the division of the share of a predeceased child when the intestate leaves a lineal descendant. If any child of the intestate has predeceased him or her but left lineal descendants of his or her own, then the share of that predeceased child that he would have taken at the time of the intestate's death is divided among those lineal descendants of the predeceased child according to the same rules as in 51. I'll explain this again. When an intestate dies, leaving lineal descendant, if any child of the intestate has predeceased him, that means there's a father's son has died before him, but he has left lineal descendants of his or her own, that is, the father's daughter or father's son has died before him but left children, then the share that the predeceased child would have taken is given to the children and divided equally if the son or the daughter, has more than one child. Next, the equal share principle for the spouse and the children of that branch with the limited parent share adjustment if applicable. This follows the principle of representation through living branches. Section 54 covers a situation where the intestate leaves no lineal descendant at all, but leaves the widow or widower or the widow or widower of any lineal descendant, the child's wife. In such cases, the property is divided giving priority to the surviving widow or the widower of the intestate, with specific allocation to the widow or widower of a predeceased lineal descendant where applicable, and any remainder following the structured scheme for the nearer relatives. Section 55 applies when the intestate leaves neither lineal descendant nor a widow or a widower nor the widow or the widower of any lineal descendant. In this situation, the property devolves first upon the father if alive. In the absence of the father, the mother and the siblings of the intestate or their descendants, that is, mother or siblings' children, if they also don't exist, more kindred according to the rules of proximity of relationship. Section 56 provides the residuary rule. When there is nobody left, there is no intestate died, obviously, there is no widow, there is no children, there are no kindred, there are no siblings, then it escheats to the government as a bona vacantia. That is a property that cannot be claimed by anybody, goes to the government finally after trying to give it to everybody. The Parsi rules under this section emphasize an equitable distribution that strongly favors the surviving spouse and the children by treating the spouse and each child as receiving equal primary shares, while allowing the parents only a modest additional fraction when the children are present. The representation for the predeceased children's branches is permitted but is carefully limited so that the extinct or childless branches are disregarded completely. There is no gender discrimination in the shares of the sons and daughters, and the scheme applies uniformly to both males and females. The Parsi intestates following the repealment of the earlier distinction. These rules apply only to the property in respect of which the Parsi died intestate. Succession to immovable property is governed by the law of the place where the property is situated, that is the domicile. While where the property is situated, that is in which state it's located in. While the movable property follows the law of the domicile of the deceased at the time of death. The illegitimate children and adoption receive limited or no recognition in the same manner as under the general provisions of the Act. Now we'll talk about the major amendments. There has been no real amendments in this except section 213. There's general overview, etc., AI jargon. Subtopic 3, final subtopic, and then we're done studying this. The gifts in contemplation of death. The gifts in contemplation of death, also known as donatia mortis causa, DMC, are a special category of conditional transfers recognized under the Indian Succession Act. They allow a person who is seriously ill and expecting to die shortly to make a gift of the movable property that takes effect only upon their death from that illness. This provision is found in section 191, which falls under part 6, the testamentary succession, chapter 10, 20, 23 of the Act, I think. I'm not good with these numbers. Section 191(1), subsection 1, states that a person may dispose of any movable property which they could have possessed or disposed of by will through a gift made in contemplation of death. Section 191 subsection 2 defines such a gift as one where the donor, while ill and expecting to die shortly from that illness, delivers the possession of the movable property to another person to keep as a gift. In case the donor dies from the specific illness, section 191 subsection 3 adds to that the gift is revocable by the donor. He can take it back during their lifetime, and it shall not take effect if the donor, after giving the gift, recovers from the illness magically, or if the donor survives the donee, that is the recipient. The person thinks he's going to die, he's going to give a gift to B, but B dies before the person. Now we'll talk about the essential requirements for a valid gift in contemplation of death. For a gift to qualify under section 191, the following conditions must be strictly satisfied, as clarified by judicial interpretations, including the reference to Supreme Court cases like Commissioner of Gift Tax versus Abdul Karim Muhammad. The property must be movable, such as jewelry, bank deposits, shares, or other personal items. The immovable property like land or buildings cannot be given via DMC. The gift must be made in contemplation of death due to an existing illness, with the donor expecting to die shortly from it, and there must be real apprehension of imminent death from that cause, though it need not be absolute certainty. Also, there must be actual delivery or possession of the property or something representing it. Like, you don't have to give the actual car, you don't have to pick it up and give it to them. You can give them a key or a document of the title to the donee. The mere intention or setting aside of the items without delivery is not sufficient. The gift is conditional. It becomes absolute only if the donor dies from the contemplated illness. If the donor recovers, the gift fails and the donor can reclaim the property. The gift lapses if the donee predeceases the donor. As I told you, if B dies, A was going to give him a gift, then the gift lapses. These gifts combine elements of both inter vivos gifts, the lifetime transfers, and the testamentary dispositions or the wills. They do not require the formalities of a will, such as attestation by witnesses, but they are subject to scrutiny to prevent fraud or undue influence, especially since they often occur on a deathbed. If a person dies, his staff or people who took care of him while he was dying, or someone who found him while dying, can just say, right, oh, he has 3 kgs of gold. He told me to take all of it, actually. Yeah, he did. But there is some scrutiny because of things like this. The nature and effect of such gift. A valid donatia mortis causa operates as a conditional gift that becomes complete and irrevocable only upon the donor's death from the anticipated cause. Until then, the donor retains the right to resume or revoke it. In the event of the donor's death, the property passes directly to the donee without forming part of the general estate for intestate succession for the purposes under the Indian Succession Act rules discussed earlier for the Christians, Jews or the Parsis. However, it may still be subject to deceased's debts or other claims against the estate. For example, a person owes 1 crore to somebody and he has cars worth 2 crores and he gives all the cars to a person. The person who has an actionable claim can come and say that, okay, he has 2 crore worth of cars, sell 1 crore worth of cars and give me the money. Or give me cars worth 1 crore because he owes me a debt and have an actionable claim. These gifts are treated similarly to legacies for certain purpose, but bypass the need for probate in many cases, making them a quick way to transfer the specific movable properties in emergencies. They differ from the ordinary lifetime gifts under the Transfer of Property Act, which we'll be studying in the second year, 1882. Section 122, which are unconditional and irrevocable once completed, subject to the exceptions. Applicability to different communities. Section 191 primarily applies to the persons governed by the Indian Succession Act of 1925, such as Christians, Jews, and others not covered by the Hindu or Muslim personal law, subject to any state exemptions notified under Section 3 of the ISA. It does not directly apply to the Hindus, the Buddhists, the Sikhs or the Jains, as their gift laws are governed by the Transfer of Property Act and the Hindu personal law, which generally do not distinguish the deathbed gifts in the same conditional manner, though some analogous concepts exist in the customary Hindu law. For Muslims, gifts during the Marz-ul-Maut, illness of death, follow the Muslim personal law principles, which have similarities but distinct rules. Example, they may be treated as ordinary gift if the donor recovers, with limited or quantum in some schools. Parsis, while having special interstate rules under the Indian Succession Act, fall under the general framework for such gifts unless they are exempted from it. The important rules, points and illustrations. That's the last slide. There's no delivery, there's no gift. For example, if a person intended to do it, a person who is sick marks the parcels with names but does not deliver them before death, the intended recipient do not get the items. The recovery revokes the gifts. If the donor unexpectedly recovers, they can demand the property back. They can ask for it back, if he does not die. Taxation and other laws. Such gifts may have implication under the income tax or the gift tax rules, though the gift tax has been largely subsumed. Although, gift tax, there you still cannot give a large amount of cash as a gift. There's like a certain limitation. I don't know if it's 25,000 or 1 lakh, something like that. And they are exempt from certain formalities, but can be challenged in court if the conditions are not met. Revocability, unlike a will which speaks from death or a completed inter vivos gift, this is a hybrid and it is conditional. This mechanism provides flexibility for someone facing imminent death to make targeted transfers of movable without executing a formal will, but it is narrowly construed by the courts to protect the integrity of the succession laws. This is a disclaimer, AI jargon. Thank you so much for watching the video. Have a nice day.